trademarks equals brands. And a trademark can be anything, can be any symbol to indicate the source of a good, and it's used to distinguish things from other things for quality. For an example, a McDonald's hamburger, it may not be the best hamburger in the world, but it's the same everywhere in the world. And that's how you're distinguishing, you associate that with a particular level of quality, and there's no deviation, typically higher or lower. And that's one way to use it. A trademark's a mechanism where a consumer can identify the source. A trademark can be anything as long as it's used in commerce. It's distinctive, it's non-functional, and the public associates it with whoever makes this, it comes from the same place. Again, they don't necessarily need to know where that place is, but they know everything comes from the same place. Here's a bunch of lists of things that trademarks can be. Some non-conventional trademarks, the shape of the Coca-Cola bottle. Yes?
So that's a trademark, but it's not trademarketable. I mean,
I'm not sure what the question is.
The question is, did they trademark that?
They didn't file a registration on it, but it's a trademark nonetheless. You don't need, in the United States, you don't, I'll get to this in a second. In the United States, you don't need to actually file for trademark protection. Trademark rights arise from use in the United States. It's not true around the world, most of the rest of the world, but in the United States, just from use. Kind of thing. Let's skip through these examples of the jeans, and Corning fiber. These are just different things that are actually the pink, the design of the jeans, the VW Beetle, the way it looks. These are all distinctive trademarks. They're used to create value. Just do it. Fred probably knows where that came from. To promote an image. I'd like to buy the world out. You'd think I'm a Coke addict, wouldn't you? You're in good hands with quality and build brand loyalty. In the United States, they arise from use, which goes back to the fact that somebody's using it in commerce gives you some rights. There's no need to file a trademark application with the United States Patent and Trademark Office. But if you don't file a trademark application, then your trademark rights are going to be limited to where you're known. There's actually some First National Banks of certain places that are actually not associated with the First National Bank, most people know, because those banks started in those cities before First National Bank of America actually filed for its registration on trademarks. Yes?
Is there a time frame involved with that? You have to leave it that way for a certain period of time?
For trade dress protection, like the Coke bottle, and those kinds of things, there's a time period. You need to use it for 5 years exclusively before you can get trademark protection on product configurations and trade dress like that. Otherwise, trademarks arise the minute you start using them, even though there may not be a lot of rights associated with them right away. Filing in the trademark office provides some constructive notice to the world that you're filing for trademark rights, so it's constructive notice to the entire United States and its territories. So there's some advantages to that. In the United States, you don't have to be using the mark to file for your trademark protection. You can file what's called an intent to use application. Before you can actually get trademark protection, you actually have to prove use, and you have to file a declaration of use. But you can file it before you actually put something into the marketplace.
Not,
That could go for a logo as well, right?
Yeah.
not to dwell on it, but for the Donald Trump trademarking, you're fired. Why and how?
Trademarks can be anything. You're fired. Probably just trademark strength is what you're going on. Here's a trademark. Bausch & Lomb got a trademark on sensitive eyes. Great. That's pretty descriptive of what they're doing. So somebody can come along and say, in normal use, essentially for sensitive eyes, that's not trademark infringement because they're just using it in the normal grammatical sense. They're not using it as a trademark identifier. At least, arguably, they're not. So you have to be careful when you file for your trademarks because you want to make sure your trademarks are over here, where they're fanciful or arbitrary and not suggestive or descriptive of what you're doing. Because the more you get away from describing what your product is, and this is kind of the issue people, especially startup companies, they run into. You want to get a trademark that kind of describes what I'm doing so people know what it's about, but those are hard to protect. The range, your trademark range is really small because you only really protect exactly your product if you're describing it. And the better trademarks are over here in the arbitrary things. Exxon, Navistar, Kodak. Those words were made up, and now they've associated with the brand, and they're really easy to protect. And Kodak's given a broad breadth of protection outside of cameras even because the mark is so strong now. Apple for computers. Apple's an everyday word, but it wasn't ever known for computers before. So when they said Apple and a computer, it's kind of in the arbitrary. It's a real word, but it has nothing to do with computers. And now they get a broad swath of protection because of that. Things that are suggestive, sensitive eyes. Yeah, you can get some protection on that, and I can stop people from using it as a branding tool, but I can't stop people from using those words in everyday commerce and everyday language. So the more you can get away from art, the more you can get to arbitrary or descriptive or coined phrases, the better off you are with trademark protection. Things over here are not as easy. They're hard. You can get protection, but you're not going to be able to get a broad scope of protection. You run the risk of descriptive words becoming just generic. Aspirin used to be a trademark. Thermos used to be a trademark. Escalator used to be a trademark. They're not trademarks anymore. Not too long ago, people remembered the whole Xerox campaign. Xerox is a great arbitrary word that was used for copiers, but people started saying, can you make me a Xerox? Well, no, even Xerox can't make a Xerox. They can only make a copy. And that's the distinction. And you want to make sure when you get words, you kind of want it to become a generic word that everybody uses and understands what it is in commerce because it means you made the big day. But then you lost your trademark rights because everybody's using it. You can't rollerblade. You can inline skate. You can use rollerblades to inline skate. And they ran a big risk of almost losing their trademark rights because people started saying, and people still to this day say, let's go rollerblading. But you're not rollerblading, you're inline skating. Rollerblade's a trademark of, I want to say Bauer, but I'm not sure.
What would be the best way to research trademark if you have a fanciful name for a device and you don't know if somebody already has it in use?
Call my partner, so I have one.
Okay.
The way to do that, what we generally recommend people to do is one, before you get a product out in commerce, don't get wedded to the terminology you plan on using. Send it to a trademark attorney, and what they'll do is they'll do what's called a search. And it's $500 or $600 for the search, and maybe another $500 or $600 for an attorney to review it and tell you what the clearance is. And these searches, what they do is they look through everything. They look through state databases, federal databases, around the world, internet searches, and they come up with a list, a booklet, it can sometimes be like this thick, of similar uses to the name that you just gave me, and a look-see to, and then an attorney will look at it and say whether you have an ability to use the mark, and if you use the mark, what kind of strength of protection you're necessarily going to be able to get, because somebody else may have already done it, and if somebody else has already done it, then you can't get a trademark on it as well. But that being said, trademarks are source identifiers, so what they're about is protecting consumer confusion. So you can have similarities. Who here knows about Delta? What is it? Airlines. Yeah, it's a faucet too. They're both Delta.
And tool.
And tool, I didn't know that. But so you can have multiple trademarks from different companies in very diverse fields. So nobody's going to think Delta Airlines and Delta Faucets is the same. Their consumers aren't going to be confused by that. And also, even if you are somewhat similar, you can enter agreements with the company that has the trademark, and there can be a mutual coexistence arrangement that can be established with people where you can actually use the mark. So there are things, but you need to talk to an attorney to get those searches and have those searches reviewed. And you should do that before you file for your trademark. And you should also do that before you get too wedded to a particular product.
If you want to trademark a slogan, like let's just take an example of I'm a hippie.
Okay.
And then you also want to use like you're a hippie, or use I am, I and the letter M, a hippie. How many of those should you file for? Variations and, Trademarks
generally protect the specific mark and the specific use. So I am a hippie, I'm a hippie, and you're a hippie, and you are a hippie would probably be 4 different filings if you wanted the most breadth of protection. As things get more famous, your ability to protect outside the actual word mark becomes broader. Toys R Us
Right.
is protected, but it can also protect from Guns R Us, and things along those lines. So as your brand grows in strength, your ability to stake out beyond your specific filings becomes greater. But when you're first starting out, you'd want to protect all of it to one extent or another. Slogans, words, the strongest mark is just a word, of course, and no particular fanciful designs, no logos associated with it. It's just a word for a particular product or good or service. If you start adding logos and you start adding designs and you start adding taglines, then the trademark range gets limited by all those different features. And you start bringing your trademark range in somewhat based on those additional features. And somebody might be able to use the word without the logo and be able to get around something unless you can prove some sort of confusion associated with it. Yes?
If you have your slogan and your name federally registered, my understanding from the last, or something that I picked up was that if you don't put the R mark with it, that you can actually use that, or that makes it stronger? Is it just there to put people on notice, and what's the value?
If you don't have a federal registration, and this isn't just an application,
It is registered.
okay, you want to use Circle R, and that's because you want to show the world that you're using it in trademark usage. If you don't police your own marks, your ability to police other people are going to be harder. And you run the risk of something becoming generic just because you're not using it as a trademark. So you want to put the Circle R for notice, and you also want to put it as in a proper use. If you don't use your trademarks properly, you're going to lose rights potentially associated with it. TM simply means you're using something as a trademark, but you don't actually have a registered trademark on it yet. You could have a filing, and that's not a registration yet. Just something being filed and something being registered are two different things.
So even if you're, let's say you're using your trademark as part of an advertisement or in a paper or anywhere, even in an article in the paper, would you always want to use the R?
Yes,
I mean, even when you're like within the body of an article in the newspaper?
at least the first time.
Oh,
Yeah, you want to at least use it the first time once. If it's a word mark and not a logo, then you're going to want to probably have it offset in all capitals versus having it in capital and lowercase. You want to make sure it's not being used as a noun
okay.
or verb.
Our trademark is all caps, so,
Okay.
yeah.
But yeah, preferably you'd want to put Circle R by all of it.